Hello?
Good afternoon. Good afternoon. I hope you can hear me.
Yes, we can hear you. We can hear you. Are you joining us from Lesotho?
Yes, I am joining you from the Mountain Kingdom this afternoon.
Okay. Good afternoon and good afternoon, everyone. My name is Faith Chabet. I work with ENS Africa, and I'll be chairing this session. I'll begin by just a housekeeping announcement that out of everyone who's in Mauritius, there's a book that was announced earlier today on arbitration in Mauritius. I think about 5 copies of that book have sort of lost their way. So if you've got a copy of it, if you're perusing, we've been requested to just return them to the main ballroom. And without further ado, I will introduce our speaker for this session. Her name is Lerato Mpaka. She is an information system professional with 12 years experience in corporate Lesotho, spanning the banking, insurance, and telecommunication sectors. She currently exercises her skills as head, strategic projects and client experience at Metropolitan Lesotho, as well as the founder and executive director of the Learning Mindset Foundation. She's also the former chairman of the MMI, Momentum Metropolitan International Millennial Advisory Board. She's currently pursuing an executive data science management certificate with the University of Stellenbosch, as well as an MBA focusing on leading innovation and change with York St. John University. She is passionate about Lesotho's involvement in the fourth industrial revolution, particularly how Lesotho can begin to take advantage of the coming human-robot relationships, humanoids, and jobs of the future to create inclusive growth for Basotho. It is because of this passion that Lerato is a speaker in these local and cross-border discussions. She will be taking us through a conversation around the Lesotho labor market and the future world of work debate in the context of digital transformation and hybrid work. I think based on her experience and credentials, we're privileged to have you speak to us this afternoon, and I will hand over the microphone to you.
Thank you. Thank you very much. I'm not sure who is in the room, but good afternoon once again to yourselves, panelists. My name is Lerato Mphaka, as has already been mentioned, and I will be taking you through some of the interesting emerging challenges, as we'd like to call them, in the Lesotho labor market, predominantly brought about by what I'm the most passionate about, which is technology. So I hope today's discussion will incite some level of conversation and thought, and also just a little bit of maybe reflection points for us, across the SADC continent, specifically Lesotho in this particular case. So I am going to be taking you through a rather lengthy presentation, but I'm going to make sure that I do leave some time for questions. Just confirm for me, ladies, if you can see my screen. You're the only two I can see on screen. So I will be picking on it.
Yes, you can see the presentation. Thanks.
Thank you. Thank you, Jatin. Thank you for that. So essentially, the conversation today, I would like to tackle by first of all giving an introduction and setting the scene so that we all understand a little bit of the labor market in Lesotho, but also the country itself. And then I want to segue into the top 5 emerging challenges that we are beginning to see brought about, obviously, by digital transformation and remote working, both now and I think into the future. There are also some considerations that we want to posit both for employees, employers, and finally just some policy recommendations and legislation for legislatures and government as well. So just for us to be aligned in this session, I think it's important for us to all get the same understanding that we applied when we were looking at the key themes in this conversation. The first being the word employee for us, we derived from the Lesotho Labor Code of 1992 that basically defines an employee as any person who works under a contract with an employer, either you're looking in the urban areas or the rural areas. The labor market for us we took the general concept, which is that it's a platform where the demand for labor and the supply of labors actually meets. So, employers and workers actually have a meeting point, and we call that meeting point the labor market. Digital transformation for us is defined by a definition coming from Accenture, which is basically that process by which companies then embed technologies across their businesses. And primarily, we know the key drivers for this would be efficiencies, agility, and ultimately unlocking value for the triple crown, which is your customers, your employees, and your shareholders. The other definition that we thought crucial was the one of the future of work itself, where we are really saying it's an informed perspective on what businesses and other organizations need to know about how work could shift, given digitization and other trends, and also how then these workplaces can prepare themselves for these types of changes. And this we took from McKinsey. And then lastly, I think an important term for us to align on would be what hybrid work is. And we're basically saying that this is a flexible work model, and it supports a blend of in-office, remote, and also on-the-go working. And you'll see that these are some of the things that we have found to create some interesting challenges and discussion points. Now, moving a little bit further, we look at the context of the country that we will be discussing. And really, it's important, I think, for us to know that Lesotho is one of the most beautiful countries in the SADC region, completely enclaved by South Africa. Population as a 2021 Bureau of Statistics was sitting at 2.1 million people. And we are quite a young population. You'll see that approximately women in Lesotho give birth 3 times as at 2020, and these are World Bank statistics. And of course, our GDP per capita, not so good. Unfortunately, we have about 47 to 49% of our population living below the poverty line. GDP per capita being recorded at $2,300 as at 2020. We have 10 districts, 10 official districts in Lesotho, and you'll then see we move quite swiftly into how employment is then structured. So the supply side of the labor market, we wanted to give you a sense of how it is structured in Lesotho. So in terms of the labor force, employed persons in Lesotho are around 520,000. We have quite a high youth unemployment rate sitting at 29.1%. You will see, however, that our labor force participation rate is sitting quite close to 50%, so 49.9%. And this is, of course, of the estimated population of 2.14. Now, looking at the composition of Lesotho's workforce, you'll see that it is relatively a young workforce, so majority of it sitting between 20 to 39 years of age, which is what I think has made some of the findings or some of the emerging challenges so prevalent in our market. And of course, you'll see that we still have quite a high dispersion of male over female. And if you dig a little bit deeper into those statistics, you'll also see, general statistics of men being in higher management positions than women are generally, and women forming, your more administrative roles in that particular market. If you look at geography, and I'll tell you why it's important when we get to some of the challenges and remedies there are, Lesotho's labor market is predominantly concentrated in 3 regions, Leribe, Berea, and Maseru, Maseru being the capital of Lesotho. So I suppose it follows, therefore, that that would be where the economic hub would be when it comes to the supply side. But there are a lot of government initiatives that are coming through in the last 2 or so years that are actually going to see us pushing labor to the outskirts of the country. So regions like Tabatega are going to see an improvement in terms of the demand for labor. We're going to see quite a lot of demand for labor in the Mokgotlong district, the Gatasnek district, as well as Mohalisuk. So that concentration of the demand is actually going to change in the next couple of years in Lesotho and kind of start moving to the outskirts of the country, as it were. Now, if you look at where we are seeing a lot of growth in the labor market, demand is quite prevalent in the services industry, and this is where you will see we've based quite a lot of our observations, particularly in the financial space where I am based. You'll also see that Lesotho has quite a high concentration of industry workers. So we're talking about people that are working in the textile industry, people that manufacture food and beverages, but we're beginning to see a resurgence of employment activity in agriculture, but also you will then see that offset by quite a high general unemployment rate of 24.5%. So, government then tries to spur this with entrepreneurship, youth entrepreneurship specifically, and also female-led entrepreneurship. Now, we also wanted to give you a sense of the demand side and who actually dominates the demand for labor. In our country, the government is, of course, the biggest employer, and government or public expenditure is responsible for 55% of our gross domestic product. And then you'll see a little bit of tempering by the private sector, so multinationals, NGOs that are coming in at just under 30% of expenditure. And then you have a little bit of that not necessarily being formally accounted for, because we do have a growing informal sector that still hasn't found its way into some of our general GDP statistics. So now that I've set the scene, and I think we're all kind of au fait with the country that we are talking about, I will paint the challenges as thus. I think in the world generally, 2020 March was the biggest tipping point that we have seen in a very long time. And it was because we were now expected as businesses to completely pivot the way that we were doing businesses because we had a global health crisis. And where perhaps legislation, policy, culture even would have caught up with technological enablement, we instead saw businesses being turned into tech companies offering specific services through tech enablement, and then leaving quite a lot of the considerations around the labor market itself behind. And so some of the emerging challenges around work and labor are not necessarily because maybe we haven't thought about the future world of work. I think we have, through the studies brought about by, McKinsey, by Deloitte, etc. We kind of know where the world of work is shifting to. But what has exacerbated some of these challenges for Lesotho particularly was that the COVID-19 pandemic forced us into a mode of working from home, even perhaps when we were not quite ready from a policy and also from a labor preparedness perspective. So I'm going to talk about some of these emerging challenges. And the first one is one that I unfortunately am guilty of, which is what we are now beginning to call the always on culture. And this is really created by the fact that we have begun to enable, we have enabled access to business systems 24 hours a day, 7 days a week. And we have also introduced quite a lot of automation and artificial intelligence to boost some of the work that we used to call manual work and that needed me to be in the office. And one of the challenges we are seeing is that traditionally, having an 8 to 5 contract, being employed and having the employer say you should come to work at 8 and leave at 5, literally meant that at 5, for some people, you had to log off, a work machine. You had to leave that particular equipment at work, and you literally stopped having access to line of work systems. But these days, because we are now allowed to work from anywhere and at any time, the idea of an 8 to 5 has been completely blurred. For some of us that are apt workers at night going early into the morning, I can actually say my 7.5 hours a day was achieved because I clocked in perhaps at 11 p.m. and then I left work, sometime in the early morning. The challenge to that is traditionally there was some form of verification to your 7.5 hours a day. You would either have a supervisor, you would have a team member around you, and later on we started seeing employers becoming even more savvy and saying we will put in little surveillance systems either on the application you're working on or as in the buildings that you're working in. So the challenge now becomes, if I am able to work at a coffee shop from 8 until 2 and migrate my work from 2 until 8:30 to my house, how do we then adequately verify my employable 7.5 hours, which to a lot of us is still tied to my remuneration, right? We are still remunerated based on how much you cost per hour to a company, whether it's through basic salary or total cost to company. And the challenge is what happens when my working hours are not as defined in the contract of employment. Another interesting challenge becomes for workers that are entitled to overtime allowances. What does that look like in a context where an employee is able to work at 1 a.m. and the supervisor is not there to negotiate upfront that this is eligible for overtime? How does the reconciliation process between the two happen? And also, where does it in the legislation say that I can actually work when line of business systems are supposed to be down, when there isn't necessarily a client to serve, and when an immediate supervisor is not available for vetting of the work that I have put through? And I think it's something that we really need to consider as an implication on people's livelihoods, for one, where performance contracts are based on the amount of hours you put in. Your eligibility for overtime is based on supervision of that said overtime. What then happens in the context where those two things are blurred as much as they have been blurred with us being able to work from home? The second challenge we've seen is this one, and this has been an age-old debate for quite some time, between information systems professionals, HC professionals, and I would imagine law as well. The idea of surveillance. Now, for a very long time, the argument has been that an employee should be surveilled when working on employer premises because of the perceived value that is encased in an employer's premises. So you think about all of the implements that would be left in an office. You think about the perception of value being you should be of service to the clients of that particular employer. And so we began seeing quite a lot of proliferation of software or devices that were able to monitor whether I was adding value to that particular organization. And it became somewhat of an acceptability, although there were still challenges on things like employee privacy. We started saying, well, yes, in the premises of an employer, it does make a little bit of sense for one to argue that we do need to check whether you're adding value. But is this argument still holding when the place of work is now my home residence? It further blurs the line of employer and employee and my private life as an employee, and the fact that in my private homestead, I should not be surveilled by a third party. And so the idea of now working on these line of business systems that still allow an employer to check when I'm logged in and out, but I am in the comfort of my own home, do pose quite a conundrum. And how then would an employer take me to task, for example, put me in front of a disciplinary committee when this line of business system says I haven't been working from 2 to 3 because I was making coffee, but this coffee was made in the comfort of my own house, and traditionally you should not necessarily know to that degree of detail what I am doing in my house. And these are some of the things that we have seen employees challenging employers on. There was a recent case in one of the telecommunications businesses in Lesotho where an employee disputed their performance management punitive measure because they claimed that the employer did not have a right to surveil them in their home of residence. And this was something that has been put before the National Dispute Authority, the GDPR, and there really hasn't been a resolution around whether or not there is precedent to being surveilled in our workplaces. The third challenge we're seeing is the one where the onus is shifting from employer to employee to provide and maintain what we call tools of trade. Now, if you think about how we described the labor market, that meeting of supply and demand has prescripts for each of the players in order to maintain that relationship. The labor code gives directive to employers to ensure that they enable employees to perform on the tasks that they are employed to do. And that includes things like infrastructure. It includes things like laptops, desktops. It includes the desks, the chairs themselves. It also includes specific structures that are meant to secure employees in their places of work. Now, the interesting thing that happened with COVID-19 was the rate at which employees were told to pivot meant that I had to provide for my own desk and chair in my workplace, which became my home office. And so you start thinking about the implications of costs on the way that we are now working. Who actually is legitimately supposed to pay for the fact that I have turned my home into a working space? Who pays, for example, if I cannot do that in the comfort of my own home and I have a co-working space, who pays for that rent? These are some of the things that we have seen being very gray, but employers have had commensurate positive changes in their costs, because as they moved workers out from offices, they started gleaning less and less costs on office rentals. But we didn't then see a supplementary shift into actually allowing for employees to be able to maintain the tools of trade that have now actually silently been shifted to them, more or less without direct consent from the employees.
Lerato, this is Faith. Just to let you know in terms of how to manage your time, we got just about 11 minutes to go. So I just thought to alert you so you can know how to manage the time that's left before the next presentation set to start.
Thank you, Faith. Thank you. Thanks. The fourth challenge for us has been around, obviously, health and safety. This is a prescript in our Labor Code of 1992, but the obligation, again, for health and safety has always been on the employer. In the event that I am no longer in the premises of the employer, but I'm doing the employer's work, the onus has somehow silently again shifted to an employee, or in the event where I'm renting a co-working space, to the person who rents out the co-working space. But again, this has not been explicitly meted out in new employment contracts. And lastly, the challenge that we are seeing, of course, is around data and infrastructure security. So in a premises that is owned by an employer, data and infrastructure security are the onus of the employer. Yes, they are the responsibility of the employee, but the enforcement becomes the onus of an employer to ensure, for example, that acts such as the Data Protection Act in Lesotho, where client data is protected and is only used for what it is intended to be used for, is monitored. Also the protection of infrastructure as well, so your laptop itself, the modems that we are using, and all of the employer software that we have loaded on our machines is actually easily monitored in a place of work that the employer controls. The question that we have started asking ourselves, and what we've started seeing as potential breaches, is where somebody is working in their household and, for example, they let it slip while making coffee, that casually client X, who happens to be a neighbor because they share that commonality with the husband, came to work. That becomes a breach of a Data Protection Act, but also leaving your device unlocked in that particular state becomes a breach, obviously, of data protection from an infrastructure security perspective. Now, what are some of the considerations that we have thought about and what we would like to posit to this forum today? First and foremost, employees do have some actions that are available to them to make this type of transition easier for them. We don't necessarily think that remote working is going to dissipate. In fact, with Lesotho's young labor market, it's only set to increase. we are actually seeing young people coming into the workspace and demanding to work from anywhere at any time. Now, the idea is you can, as an employee, tackle being always on. And some of these things might sound primitive, but if you're working in a culture that still believes in attaching performance to the time spent, devising a timesheet of activities and then agreeing to those upfront with your manager becomes a good way to manage expectations on time spent on work. Advising the manager as an employee to consider measuring you on outcomes-based performance as opposed to time spent becomes something that you can consider doing. So basically asking your manager to give you goals and then saying, track my performance against the completion of the goals as opposed to how much time I've spent doing a particular task becomes something of an avenue for you to consider. The other one is there will come a time, I think, where a lot of employers are going to begin revising employment contracts. And it is your responsibility as an employee, therefore, to actively participate in that revision. Employers generally will ask through surveys or focus groups what works in a remote environment, what you have learned, and that becomes your opportunity to craft an employment contract that works in your favor. Answering the challenge of the shifting onus of the tools of trade and who should maintain them. As an employee, you can actually document the supplementary tools of trade that you have had to equip yourself with, and obviously be wary of upkeep cost and depreciation factors. Now, we do this because when you come and negotiate for a salary increment, you would essentially, as a prudent employee, be able to start including considerations around the upkeep and depreciation of the tools of trade that you now have to provide yourself. Now, in terms of how you would best maintain infrastructure so that you're still on the right side of company policy, it is your onus as an employee to ensure that you upkeep maintenance regimens such as upgrades of software that employers regularly send you as an employee. And if this means coming into the office, it does actually require that you do so that you don't find yourself compromising both the company and yourself running things like outdated software or even running machinery that is outdated and in need of repair. If you think about how you can tackle the perceived lack of surveillance, timesheets as well would work here, where actually if you have a timesheet, it does then negate the need for constant surveillance. What you can do is obviously reconcile the times between a line of business system and what you would have clocked on your timesheet, but also that overall negotiation of outcomes-based performance as opposed to time spent would become a panacea, I think, to a lot of the issues that you would have there. When it comes to data and infrastructure security, I mean, the same office rules should apply here for employees. Just because you're in the comfort of your own home does not mean you leave your device unlocked. And just because you're talking to your spouse does not mean that company information becomes home information. These rules would still apply in the context of your own home. Thinking about employers, taking a different spin on tackling always being on, we definitely as employers need to consider remote working policies to avoid ambiguity. And these would include what time is a work time, whether or not we are still considering time as a percept of performance management or considering, outcomes-based performance management regimes. Timesheets as well are something that managers need to actively enforce so that it's not just the onus of the employee to clock time, but it becomes the onus of the manager to negotiate and also to check on the time that has been clocked. If we look at legislatures and government, because I think this is where a lot of the enabling ground needs to start. When you think about the tools of trade, one of the reasons why it is expensive and onerous for employees to take on tools of trade is because we don't have national infrastructure that supports things like co-working spaces in the main economic hubs. And so as an employee, I am now faced with the challenge of maintaining an always-on culture in terms of access to data. I now have to make sure that I relocate to an area where there is adequate provision of network infrastructure And if government were to accelerate some of its ICT revolution plans, as they have been called in the National Development Strategic Plans, then these are some of the things that we could look at advancing in order to ensure that we are still keeping the equilibrium between employer and employee in the labor market. The other one is, of course, the revamping of provisions of health and safety regulations so that we include the working from home as a scenario to health and safety regulations. We start understanding that this also includes a little bit of worker upskilling, and it should be at the cost of the employer, but it should also have a basis of protection in the event that an employee either forgets to do a health and safety check or the employer forgets to do a spot check, particularly where there are remote workers that are in dispersed areas of the country. Now, the other one is, of course, we need to have a stance on the idea of surveillance. So what is the stance of legislation when it comes to the issue of surveillance, whether it be in the home or at the workplace? And I think here we've seen quite a lot of good progress from government in involving, the labor market itself in coming up with some of these solutions. And we believe this would also help as well. The other one, of course, being, the labor code needs to start moving itself from an 8 to 5 or an hours-based definition of a work day and moving itself to a more outcomes-based way of measuring work. So firstly, identify what outcomes would look like in the different areas of economic activity that we have labeled, and then begin defining what it is that an employer could consider a contribution, a valuable contribution to outcome by an employee. I want to perhaps stop here and take questions, and I suppose some of those questions may lead me to talking about some of the things that I tried to gloss over as a result of time. Thank you.
Okay, thank you, ma'am, for the presentation. My name is Matilda, and I'm from the DPSA in South Africa. That is the Department of Public Service and Administration. I'm in the discipline management division, where we develop policies on disciplinary codes and policies around that area. But my main point of interest is around the issue of control over working remotely. More importantly, with regard to the issue of control, because basically the employer has got a right to control and monitor the hours of work that the employee services the department, and also vis-a-vis the employer also has got a right to those services, or let me put it the other way, the employee is obliged to give certain hours of work as service to the employer, and the employer also has got a right to those services. So what did your perhaps your research or your in preparation of this presentation look at the implication in that regard? Because obviously we have seen cases whereby employees will take advantage of not giving the full hours of a day's work that is required to render those services. And equally, the employer will not monitor whether there is service delivery or either they are getting the services that they are supposed to get. Because we all know that in the place of work, if you don't give your full might and the full period of a day, service become affected. So how do we go around maneuvering those kind of challenges? Because we cannot go back to the policing, which doesn't work. We know it just doesn't work with policing employees, but we need to make sure that employers get what value for the services that they pay their employees. And also another point is on senior employees. We know that especially senior management employees are not obliged to be in the office for the full work of the day, for the nature of their work, attending meetings and doing the traveling in between the meetings and so forth. But with the with the remote working, we understand that can be managed because you don't have to drive to that meeting anymore. You don't have to drive to all over the place to get to those meetings. But then how do we manage that also? Because the employer saves costs on S&T, I mean travel and subsistence, paying those reimbursements for costs, and also the data. I hear you mentioned it, but not into that detail. The costs for that connectivity, it also bears costs on the employer. But then how do we manage that? Because it somehow to extend have some way of being left to, we'll see how to deal with it in the future. But those are the serious implications that we see. They really affect service delivery. Thank you.
Absolutely, absolutely. I don't know if you want me to address your question first.
There's just one other question. I think we can take it, and then you can answer both very quickly because we are already out of time to allow the next question. But yeah.
Certainly. Thank you.
Thanks for the presentation. Just two quick issues. So what will be the best model of ensuring that you take care of occupational health and safety, issues for purposes of remote working? Would it not be better to accept that between the parties, of course, that whichever that the policy could say, if I choose to work from home, I, as the employee, am actually tacitly declaring that my home is safe enough for me to work from. Because then otherwise, how does the employer ensure that my own home is safe for purposes of productivity of work? And you just the clarity around the expenditure, the public sector expenditure. You said 55% of expenditure comes from the public sector. Is this the total expenditure that government puts into the economy to stimulate the economy, or is it related to just the cost of public administration? Just what I wanted to check. Thanks.
Thank you. Thank you. Let me start with the first question that was basically talking about the remedies that we can afford, particularly managers, when it comes to the idea of surveilling time. So one of the recommendations that we are putting forth is that the idea of time is very onerous for an employee and a manager to ensure that it is being kept. There are ways, and we have actually piloted a few. So for example, the idea of timesheets is an age-old practice, and we used to do it, and your manager would come and at the end of the day sign off that you have actually clocked your 7.5 hours a day. What we piloted in our business was we actually did upfront negotiations of timesheets. So I would declare as an employee that, for this week, I'm going to start working at 6 p.m. and my 7.5 hours ends at this particular time. And I will likely be logged into system X, Y, and Z. And so if you're looking for a culmination of my timesheet, we can actually cross-check against, user logs that are in systems X, Y, and Z. There are gaps here. One being sometimes I may not end up being in systems X, Y, and Z. And to your other point, the manager still has to go and honorously check X, Y, and Z systems to ensure that it does actually culminate to my 7.5 hours a day. And this is why we said alternatively, and what I think will predominantly start working is what we call outcomes-based performance management. So don't manage my time, rather manage the outcomes that I produce by negotiating with me upfront the goals that are going to constitute the money that is going to be allotted to my position. So if you give me 5 goals and you tell me the measures through which you're going to then attribute my performance, it becomes very easy for the both of us to check progress for one, and also to eventually agree on whether I've met my goals. And this has nothing to do with the time that I've done them in. Oh, what I would be looking at is, did you actually do X and Y as we agreed? Did you meet stakeholder X and Y, and were they happy did they sign that you came to meet them? And it becomes a negotiation on value creation as opposed to time spent. And that amount of onerous checking against systems and timesheets and upfront negotiation actually becomes a little bit less of an issue to manage. The other one that you talked about was, employees that are not mandated to be in the office. And I think there are a couple of considerations employers perhaps missed to their detriment. The first was, if I am allowed to attend a meeting virtually, I should also ensure that the leakage that normally happens when it comes to things like allowances must stop, so that those allowance leakages can be moved to things like the acquisition of data. The other one becomes, if you don't want to acquire data on an event basis, a lot of employers started buying equipment for employees. So, they bought modems, they ensured that on a monthly basis, these modems were loaded with data, but they also started asking for activities to be logged so that we are clear that you are actually attending your meetings as you have been requested to, without necessarily then incurring some of the costs associated with car wear and tear, mileage, etc. And where those things have worked well, where you find that an employer has decided to completely remove mileage costs to discourage employees from going to meetings physically, you have seen then a commensurate increase or shift in cost to things like data. But also what you're seeing is you are beginning to get a bit more feedback out of meetings with clients, as opposed to what we used to see before, which was that, I'd say I've gone to a meeting, but you couldn't even verify. Whereas now, employees are actually volunteering meeting recordings as a way to show that they are actually adhering to the promises that they have made. So that's a consideration that I think employers need to do, to kind of outline what it used to cost to work physically, and juxtapose that with the reality of working remotely, and then offset costs against each other so that we can enable remote working as much as possible, but also then ensure that we prohibit employees shifting back and forth and essentially duplicating costs in that manner.
Okay, Lerato, I think we need to now wind up. We're almost 10 minutes into the next session's time.
Certainly.
Yeah.
Okay, I think I will, if I can be allowed to address the last question, because the other one was really for information around the health and safety. So yes, we do agree that tacitly, in a new employment contract, if you're an employee and you volunteer to work from home, you would be tacitly agreeing that you now take on the onus of health and safety, but it must come with training from the employer. Because as it stands, if you're not a health and safety practitioner as an employee currently, you don't really know what constitutes a good working environment. And so if employers don't meet employees halfway to deliver that training, it will actually be detrimental if you ask an employee to admit that their workplace is safe when actually they don't have the knowledge to understand whether that workplace is safe. And then also the supplying of the enablement tools. So ensuring that every home, for example, has a health safety kit becomes something that I think an employer needs to consider, so that when you do ask an employee to sign on that dotted line, you have actually tried to balance the responsibility between the two of you, and not just, tacitly shift the responsibility as we have been seeing of late. With that, thank you very much, colleagues, for your attention.
Thank you so much, Lerato. Unfortunately, time is hardly ever enough for very interesting conversations such as this, but we thank you for your time. Yeah.
Thank you. And I hope to be invited again in the future. Thank you.
Thank
Thank
you.
you.
Thank you, Mpedi.
That's great.
Hello, good afternoon, and welcome everybody for our participants present here and everyone online. We're going to be looking at labor law, optimization in a volatile, uncertain, complex, and unambiguous global environment. To take us for this session, we have John Botha, and he's a specialist in workplace strategy, transformation, and planning. He has held a global executive position for a global workforce solutions provider for many years. He was a negotiator at Letlhokwa for around 7 years and represented SA at ILO, ILC on three occasions, in Geneva. He holds a BCom honors degree, a postgraduate diploma in labor law, and a certificate in design thinking from MIT in the USA. John also has more than 20 years experience in employment equity consulting. Without wasting too much time, John, you have the floor and the audience are ready. Thank you.
Thank you very much. Good afternoon, everybody. My apologies with the technological issues. I'm going to get straight into the work of the day. I look forward to spending the next few minutes with you just talking about what I see unfolding from a labor law point of view, not only the legal contract, but the psychological contract that employees have with the employer. One thing that has always occupied my mind, and if I look ahead, is where labor law is heading towards and whether or not organizations and employers are keeping up. So if I take a look at the volatile, uncertain, complex, and ambiguous environment, the reality is there's a huge amount of performance expected from organizations, especially from a labor law point of view. Organizations are very set in terms of compliance. Organizations want to optimize their positions in the context of labor law. And the expectation is to see a beautiful picture like the one you see on the screen right now. People just want to see the beauty, the power, and everything being done without any hiccups. The truth, however, colleagues, is that if we look at the labor law environment that is unfolding in the fourth industrial revolution, and as we move deeper into the fourth industrial revolution, in fact, some people think we're on the cusp of the fifth industrial revolution. It's more like what you see here: complex, interrelated, and dynamic environment like this instrument board on a 747. There are alarm bells, there are switches, there are levers, and all of these have to come together in order to meet the increasingly complex requirements of labor law. When I talk about complex, I'm not talking about the application and the interpretation of labor law. For today, I'm talking specifically, colleagues, about the issue of the psychological legal obligations of employers. You might say, but John, what are you talking about? Well, I'm talking about the world in which we find ourselves and the response of the ILO, the response of the World Health Organization to the employment relationship. The World Economic Forum put these 10 severe risks on the map, from climate failure to hazardous diseases like infectious diseases, to social cohesion, debt crises, and natural disasters, and of course, geopolitical unrest. And if we take a look at these disruptors, we can specifically look at the legal response to this. In most geographies, we've had a very definite legal response to COVID-19. We've had a legal response to technology. We've got cybercrimes legislation and protection of personal information. We've got social unrest. Some of our geographies are amongst the most polarized in the world. The World Health Organization is saying this year of 2023 is the year of employee well-being, because they're saying that employees are so pressurized external to the work environment that laws need to ensure that when people enter the work environment, they are not toxic environments. In other words, they don't want people's increasing mental anxieties, depression, and burnout to be exacerbated in the workplace. And that's why more and more legislation, colleagues, is becoming focused on not only the written legal contract, but the psychological legal contract that employers need to ensure represents the cultures in the organization. The culture, leadership set the tone. Now, if we take a look at the industrial revolutions, this diagram shows you where labor law is heading. And very briefly, of course, in the first and second industrial revolutions, if you've watched Charlie and the Chocolate Factory, the master-servant relationship, where everything was about the company, the shareholders, and it was autocratic and authoritarian. Labor law started maturing, and in the 70s, 80s, and 90s recognized basic fundamental rights like leave, sick leave, family responsibility leave, overtime pay, etc. But even then, colleagues, it was still largely based on management prerogative. The managers could be very focused on the task, but didn't have to spend much time empathizing with their staff. So you had in the third industrial revolution, people who were successful managers were managers who were control, they were instructing, they were poor at listening, and ultimately they were critical, and they chipped away without recognizing people arrive holistically. They arrive with their divorces, they arrive with their financial problems, they arrive with their health-related problems. And labor law started taking cognizance of this by including additional dimensions and rights. So job applicants, for example, could not be discriminated against on the basis of race, gender, sexual orientation, religion, belief, culture. So now you see labor law starting to go out of the paint by numbers world into a world where human dignity and mental well-being is being articulated, and saying any act that undermines human dignity is no longer going to be acceptable. So it was not just about procedural and substantive unfairness, but labor law started going into the world of saying we need a human-centric. So in South Africa, for example, we have recently had a code of good practice on harassment being promulgated, which aligns to Convention 190. And Convention 190 of the ILO talks about preventing and eliminating harassment. And for the first time ever, colleagues, the code of harassment requires employers specifically to do risk assessments, to say which job types, which genders, what circumstances lend themselves to harassment more than others. Specifically, if I have to get into the detail, the code on harassment says you may not roll your eyes at your colleague. You may not joke at someone's expense. You may not constantly criticize someone to the point that their dignity is undermined. You may not marginalize people. And of course, the labor laws are saying, if you want a highly productive work environment, if you want an innovative and collaborative environment, which is essential for survival, to have a diverse, equitable, inclusive, and belonging culture in your organization. So we've got the Cyber Crimes Act, which says you cannot do what you want to do on digital platforms to the extent that it is harassment, threats, or violence, or images of people that are unauthorized. We have the Protection of Personal Information Act, which recognizes that certain types of information have to be so protected and kept confidential because they potentially can undermine the human dignity of individuals. So what I see happening going forward, colleagues, is in the fifth, now already, but certainly in the fifth industrial revolution, we're going to have more and more laws which entrench legal provisions around non-toxic work cultures. Toxic managers are going to be exposed, and they are going to be demonized, and they're going to be ejected from workforces, because toxic managers set the tone, and as a result of that, their toxicity it permeates the entire organization. And already we see in organizations, since this awareness and risk assessment and litigation has started taking effect around harassment and unfair discrimination, we are seeing the purging of people who might have been good managers in the third industrial revolution, but who are very poor leaders. Colleagues, remember, managers take charge of their employees, and that is necessary because the work needs to get done. But leaders take care of their employees. And labor law is starting to embrace both aspects and saying, not only do you need to look at the task of labor law, but you need to immerse yourself in the human-centric point of invest their lives, their careers, their hopes, their aspirations, and their livelihoods and their self-esteem. So if we look at the design principles for workforces and we see the laws acknowledging this, organizational leadership and culture are becoming critically important. In South Africa, our Employment Equity Act compels employers to take steps to further diversity at the workplace. It's not a suggestion, it's a legal obligation. Our skill sets have to start including leading and managing with emotional intelligence. We need to ensure that we are agile and innovative, and labor law is increasingly recognizing platform work. We've got a bill coming through Parliament that will regulate platform work where Uber drivers, Checker 60, Take a Lot, all these massive platform workers get more protection. We obviously have to be human-centric. We have to look at employee well-being, governance, and compliance. And colleagues, that is exactly why I'm saying today, we cannot use old mindsets to solve new problems. From a legal point of view, we've got to not only look in the mirror and say, do we have cultures in organizations, cultures of inclusion and diversity and fair discrimination, but we also have to say, how are our workforces structured? And what we're seeing is a migration along this value chain where the agility and the innovation and the responsiveness required of organizations is meaning that people are not only being employed directly immaterially, but they are now starting to look at alternative forms of work. And movements like the 4-day work week, for example, movements around more flexible working arrangements and the impact on gender equality are gaining momentum. And again, it's not only based on the contract of employment, but based on the human needs and the balance required of human beings. So we see different classifications of work and with different protections attached to them. So more and more people are becoming flexible in their approach. Platform workers, we see legislation extending to protect them, independent contracting, temporary employment services and temporary work agencies, and then obviously direct employment. So the question then is, do a reality check and say, are we flexibly enough positioned and are we managing our risk effectively in a highly volatile environment? I think just in conclusion, the question is, how do you stack up? How do we stack up as individuals? You might say, John, what do you mean by how do we stack up? My question is twofold. First question, are we integrating the psychological contract into our policies, our procedures, and our cultures? Are we ensuring that people can be vulnerable at work? Are we ensuring that people will be heard and collaborated with in designing solutions going forward? Or are we stuck in the third industrial revolution of command and control? Because the latter are toxic environments which destroy not only businesses, but destroy individuals and their careers. And then the second question today is, how well are you incorporating the legal contract provisions and changes into your employment contracts and your policies? When last did you revise your disciplinary code and include cybercrimes, poppy, cannabis, and other types of new trending issues into your disciplinary code? When last did you review your grievance procedure to cater for harassment where the person doing the harassing might very well be the superior, and you need an alternative channel for people to pursue? So I think the lasting sharing point for me for today, colleagues, before I hand back to the program director, is to say in this world of change, we've got to understand that change brings with it emotions, shock, denial, frustration. Think of COVID-19. Leaders, and if our labor laws did not recognize the human response to change and require companies to be more human-centric, then, colleagues, the change curve would be longer, deeper, and more disruptive. And many companies don't ever emerge from the other side because the companies address this as a task and they are not human-centric. We have to understand that connection times task equals results. We've got to understand that building in relationships of trust, underpinned by fairness and underpinned by compliance, will ultimately mean more agile, less resistant, and collaborative and innovative solutions. So it's time that we think of this, because behaviors are the most difficult things to change. You can put employees into a training venue and train them on knowledge and skills and get a quick result. But when we have to change personal behavior, it's a longer process, and very few people actually are able to transition to. And that's why we've got a lot of managers, but we've got very few leaders. And labor law is saying we need both. We need leaders and we need managers. We need connection and we need task. And we need to ensure that we combine these two to create trust. So, colleagues, effectively, that is really what I wanted to share with you. My lasting comment to you is to say, look at the evolution of labor law from master servant to employer employee to being human centric, to recognizing not only the written legal contract, but to legislate the psychological contract between the employer and the employee, because people arrive holistically as human beings, and that has to be part of the consideration. Thank you, Program Manager. Back to you.
Thank you so much, John, for the presentation. At this point, we'll take a few comments, questions, clarifications. Do we have any messages online? Yes, please. Okay, before we go to the online, you go ahead.
Oh, is it
My
off?
apologies.
Oh,
There we
so
go.
sorry.
There we go.
My mic was off. Good afternoon. My name is Mamurena Madisha from South Africa, Johannesburg. My question to you, John, and thank you for the presentation. With the world of work and us navigating towards a human-centric labor space, is it not time that we perhaps, and when I'm saying we comprises of ourselves as trade union officials, that's who I'm representing. So we, trade unions and the employer, is it perhaps not time that we stop selling hope to employees? That's if we genuinely really need employees to be effective participants within the labor ecosystem. And let me qualify that question quickly. So you made a very important statement about, exposing toxic management or toxic managers in the workplace. And we know as we sit here that toxicity in the workplace has been there long before COVID. And yes, of course, it has gained strength over the years. But the reality, John, is that there is no consequence management for such managers or for that kind of management style. I'm sure recently you would have seen there is an Standard Bank case where actually the labor court has ruled that that particular toxic manager, the branch manager, must actually be reinstated. And in part, the judge is saying, if indeed the case here is incompatibility, what was done internally, and so forth and so on. Now, my interest is the employees, because that is my constituency. And I find that if we keep promising employees or giving them hope that the workplace is a place of happiness, and one day it's all gonna be okay. One day these bad managers, we are going to find them and we are going to deal with them. We are creating a working population of people that then have this expectation, and this expectation grows on a daily basis. Every day when they come to work, they have hope. And as a result, they do not know how to self-cope. They do not know how to self-regulate. On a daily basis, and it can be 6 a.m. in the morning, it can be a Sunday, it can be a Saturday, even on a Christmas day. As a shop steward, a full-time shop steward, I receive calls from employees that say, I actually am ready to hand in my resignation because this is how frustrated I am. I've done this and that and nothing happens. And half of the time, they obviously don't appreciate my response, because my feeling is selling hope to them that it's going to be okay, doesn't work. But equally, I'm not saying let us be prophets of doom. But is it not better that we rather empower employees to start, what's the word I'm looking for? To have a mental paradigm shift, to know that the workplace is not our kitchen. The workplace is not our lounge. You are going to get a manager that does not like you, but this is how you can cope. This is how you can respond to it. And, don't allow an individual, irrespective that they pay your salary, to push you to a point of being temporarily incapacitated, because it gets to that point. I'll pause there.
No, exactly. No, your question is, and your comments are well made. And my short response to that is leading and managing with emotional intelligence. There's a reason that the World Economic Forum has said emotional intelligence is one of the top 10 skills, because emotional intelligence can be nurtured, can build resilience. You can build the capacity to build better interpersonal skills. The challenge, of course, is on the slide on the screen. The challenge is it takes a lot of time and effort and sacrifice to be a leader, because remember, a leader takes care of their staff. It's easy to issue instructions and to tell people what to do, but it's more difficult to empathize with them. And organizations that mean business are going to have to spend more time on enabling and capacitating people in resilience, interpersonal skills, to understand themselves, to understand others. And the sad reality is it's going to take time, and there's going to be few people that make that transition. And that's exactly your point. We have got organizations full of managers, but not necessarily leaders. And it is going to take time. What I do want to say, and unfortunately, colleagues, I have to end on this note, you to this model. It's called the Lencioni 5 dysfunctions of a team. And I think the comment I have in response to you is a challenge to trade unions, employers, all stakeholders, and even us as individuals. Organizations that don't have trust In other words, where people are not allowed to be vulnerable, those areas of lack of trust leads to negative conflict. And where there's negative conflict, people are not committed. And when they're not committed, they avoid accountability, and ultimately results suffer. And we have seen examples of businesses where there is too much management and too little leadership. And we need only look at Kodak. We need look at Musica. We need look at brand names that have closed down and liquidated, not because of technology, not because of economic. They got people in leadership positions who are not open to discomfort. They are subject to the limitations of their own minds, and they then want to impose those limitations on everyone else. So the only answer I have, and you know what's interesting, and I'm so pleased you raised that, it's already legislated. Colleagues, the Employment Equity Act in Section 15 already says you must take measures to further diversity, which includes EQ. The Code of Practice on Harassment in Section 8.1 says you must do a risk assessment, you must do awareness training. And leaders of any organization need to be taken on head to head, because they will destroy the business, they'll destroy the organization. But colleagues, my sincere apologies. I'd have loved to have been with you. I have to run. Many blessings. I hope to catch up with you. Goodbye.
Goodbye. Thank you so
Thank
much,
you,
John.
bye.
We're grateful for your time.
Okay, so welcome everyone to this session towards the end of the day. Our first presenter is Krishni Appadoo, and her topic today is the impact of COVID-19 on employee mobility in Mauritius, the scope for hybrid remote work through technological innovation. Krishni is a lecturer in law at the University of Mauritius. She has interest in environmental law, climate change law, policy, diplomacy, international commercial arbitration, communication skills for lawyers, information technology and law. So this research is, I believe, revealing a set of preliminary findings from a survey that's ongoing at the moment. And so the floor is all yours, Krishni. Thank you.
Thank you, Pratima, and hello, everyone. Good evening. And I'm sorry I cannot be there physically, but I hope that you find this presentation interesting. As Dr. Sambajee mentioned, this research is ongoing. And as you can see on the screen, this is the title. And I will just go through the presentation with you. I hope you can see the slides. Is that okay, Pratima?
Yeah.
The slides?
Yeah.
Okay. Yeah. Okay, so I will first go through the rationale for the research. As everyone knows, and it is tried, COVID-19 has had an indelible mark on our lives, and has transformed the way in which we function in society. It has challenged us to look at the way we interact, we consume, we work and travel in a different way. At the height of the pandemic, one of the most pressing challenges that was faced by employers and employees around the world was the ability to still continue keeping businesses and offices functioning. And this was because of strict lockdowns that were imposed, and these obviously had an impact on employee mobility issues. So a breakthrough was hailed as both employers and employees navigated the uncertain waters of work from home. So it's a term that has been on everyone's lips since the lockdown, and also known as remote work or hybrid work. So as we now come to terms with the pandemic, and as we settle into the new normal, most workplaces around the world have maintained some form of remote work. Others have allowed the employees to keep working from home indefinitely. And in 2020, mobility is one of the most important issues for human resources to grapple with. With technology, employees are finding that remote work have multiple benefits, including the possibility of greater work balance and the ability to organize one's work according to one's lifestyle. However, despite these advantages, hybrid work do come with its load of limitations and challenges, such as an invasion of the employee's personal space and an increase in financial costs associated with heating and cooling of home workspaces, especially as the seasons change, the cost of desks, office space, chairs, and related equipment, as well as internet connection costs. So what is the situation in Mauritius in terms of remote work? In Mauritius, the government has been at the forefront of enabling employers and employees to roll out remote work during the pandemic. So we were very quite lucky, actually. For example, we already had in place before the pandemic a few legislations that had already made mention of the possibility of working from home. So during the pandemic, we have had two pieces of legislation to that effect, namely the Workers' Rights Working from Home Regulations 2020. So the Workers' Rights Act was amended to cater for this, and the Work from Home Protocol for the Public Service 2021, which was deployed during the second lockdown. However, in Mauritius, employers have been less keen to extend remote work beyond the pandemic due to organization and cultural bias, a lack of strong institutional and legislative framework, as well as distrust towards employees. It has been argued that the legal framework of remote work in Mauritius is quite loose and liberal. This was argued by Sorefan in 2020, in as much as the specific policies and legislations allow employees and employers to be flexible in how they plan remote work arrangements. This can be seen as both a disadvantage it can both be seen as an advantage and a downside, in that both parties can navigate around the provisions of the law without any strict requirements. So what have been the aims and objectives of the present study? So the aim of this study is to determine the effectiveness of remote work arrangements in Mauritius and assess how technological innovation can help shape the future of hybrid work in Mauritius. The objectives will be to analyze the current policies, laws, and frameworks regarding remote work in place in Mauritius, evaluate the effectiveness of the different strategies that have been adopted by employers to roll out remote work throughout the country, assess the role of technological innovation in driving forward hybrid work in Mauritius, and we intend to do this by comparing with the situation in other countries that have adopted some form of hybrid work, identify obstacles in rolling out technological innovation to implement remote work in the country, and finally to propose recommendations to successfully incorporate remote work through technological innovation into the Mauritian employment landscape. So the methodology that has been used is a literature review of studies on remote work in Mauritius, a quantitative study to assess how private and public institutions across the island have rolled out remote work during and beyond the pandemic. This is being done through a survey questionnaire, and the sample size is of 400 respondents. The population is private and public sector institutions, and we have targeted 4 sectors, which are the financial services, education, IT, and medium and micro, small, and medium enterprises. And we also intend to do a qualitative study in the final stages of the research. So we will be aiming to interview around 10 respondents. So I will go through a very quick definition of remote work. Currently, as per the International Labour Organization, there is no international statistical definition of remote work. However, remote work can be described as situations where the work is fully or partly carried out on an alternative work site other than the default place of work. So remote work can be performed in a variety of possible locations, all of which can be viewed as an alternative to the location where the work could typically be expected to be carried out, taking into account the profession and the status in employment. The arrangement to work from an alternative work site has to be approved by the economic unit on which the worker is dependent. So we have certain variations of remote work, which include teleworking, working at home, and home-based work. And on the next, on this screen, you can see how the International Labour Organization has tried to categorize the different types of work from home. So let us focus now on remote work in Mauritius. So there have been, since many years, even before the COVID-19 pandemic, calls to introduce flexible working hours in the civil service since the 2008 Pay Research Bureau report. So the benefits for flexible hours were highlighted in the 2016 PRB report for both the organizations and the employees. So this is mainly for the public sector. So for the organizations, the advantages are improvement in productivity, reduction in absenteeism, less requirement for overtime as employees can manage busy and slack periods, completion of lengthy work assignments without resorting to overtime, potential for longer opening hours and public desk cover in the flexible periods, including lunchtime, and balance in family life and professional activities. So in the same PRB report, the term flexi-place and home working were further introduced. So flexi-place in 2018 in the PRB report was defined as an arrangement whereby staff perform work in places other than the office, and home working as an arrangement involving people undertaking work primarily in their homes or who travel extensively but are primarily based at home. So what was the COVID-19 response in terms of remote work in Mauritius? To restrict the number of officers in an open office setup to ensure social distancing and also to have less commuters, the government approved the work from home scheme, which was introduced in the public sector in 2020. More specifically at the beginning of the first lockdown in March 2020. The scheme was introduced for an initial period of 3 months on a pilot basis, and under such a scheme, the supervising officer and the employee mutually agree on certain deliverables. With this change in the work environment due to COVID-19 pandemic, the Workers' Rights Act 2019 was also subsequently amended, more precisely Section 17A, where the employees are notified with a prior notice of at least 48 hours by the employer for working from home arrangements. So the government of Mauritius supported the scheme by providing additional allowances to cover for internet access and phone costs. There are currently, there have been a few studies that have been conducted to assess the effectiveness of the work from home scheme in the public sector. One such study is by R. Debary, who highlighted some of the reactions of employees regarding the work from home scheme. So Debary found that as many as 68% of respondents were favorable to adopt the work from home mode of work, with 47% considering this option very favorably. Of those who have responded highly favorable to work from home, the majority were indeed female workers. It was also observed that employees in the supervisory grade in public institutions constituted around 38% of those who were highly favorable to work from home. This was followed by 38% in the middle management grade. So respondents were asked to name the 3 biggest challenges they perceived when working from home. Given the nature of work, especially in the civil service, since the majority of the respondents are from this category, many of the respondents, about 68%, stated that accessing information to get their work done from home was seen to be challenging. Around 47% indicated that lack of equipment such as a PC or laptop and internet connectivity would limit working from home, and about 40% reported that collaborating with colleagues would be difficult. Around 26% of the respondents stated that they would struggle managing time to keep a regular schedule. So all of these can be seen from the 2 figures that have been extracted from Debary's research in 2021. So when it comes to the survey that is actually being carried out, we have, as I've mentioned, a sample size of 400 respondents, and we have been getting responses so far from around 100 respondents, and the preliminary results demonstrate the following. Work from home strategies were favorably welcomed by employees from the above sectors, as mentioned above. And initial reluctance from employees was limited, except in workplaces which did not have a preparedness plan for deploying work from home arrangements. Employees in the public sector struggle more with work from home arrangements due to the following reasons. They are lack of a preparedness plan prior to COVID-19, lack of consultations between staff representatives such as unions and employers when finalizing work from home arrangements, lack of appropriate resources and materials such as stable internet connection, office space within the home, hardware and software facilities, health issues connected with working for too many hours at a desk at home. These include physical illnesses as well as mental health conditions, difficulties to disconnect from work while being at home, and inability to cope and juggle with household responsibilities and work from home. So it is also being seen through the preliminary results from the survey that women are bearing or have borne a heavier burden in terms of limitations of work from home. Institutions and organizations which had a preparedness plan were better able to move seamlessly to work from home arrangements when the first lockdown was announced. For example, the University of Mauritius already had an online learning teaching policy in place, which made it easier for staff to deploy work from home arrangements. Employees found that incentives for work from home from employers gave them motivation, including internet allowances, provision of hardware and software facilities such as headphones, laptops, graphic tablets, offer of online trainings to improve their IT skills and proficiency. Employees would have liked to have the possibility of work from home even beyond the pandemic. So how is remote work doing around the world? As can be seen from the figure on the screen, as per a report by McKinsey in 2021, we can see that there are different work arenas that have been impacted where high physical proximity were most disrupted. So we can see, for example, classroom and training, on-site customer interaction, computer-based office work, indoor production and warehousing, as well as other areas such as outdoor production and maintenance and home support. So as can be seen on the next screen, there has been an increase in occupation transitions between pre and post COVID-19 scenarios, and this will continue to happen until 2030. And labor demand will also shift across occupations. So there will be a greater need for workers in the following services: the business and legal sector, health aides, technicians, the wellness services, as well as STEM workers, and also in the transportation services. So where does technology fit into all of this? There has been a marked rise in the use of robotics, robotic process automation, and AI, artificial intelligence, both in production lines and within workspaces across the world, further to the COVID-19 pandemic. Companies have enlisted automation and AI to cope with COVID-19 disruptions and may accelerate adoption in the years ahead, even beyond the pandemic, putting more robots in manufacturing plants and warehouses and adding self-service customer kiosk and service robots in customer interaction arenas such as supermarkets. This will no doubt affect employees working in these sectors when automation is called upon to replace humans. And this is already taking place. In this scenario, companies which are using automation and AI should invest massively in retraining and redeploying the existing staff within the organization. For example, in 2020, IBM, Bosch, and Barclays started apprenticeship programs to train workers for tech jobs with career pathways. Businesses and policymakers have a role to play in rethinking, retraining, and finding new ways to help workers develop the skills they will need. If a robot can learn to flip hamburgers, then a shop clerk can learn to be a nurse practitioner, a cybersecurity analyst, or a wind turbine service technician with the right training and with the right support from the organization. Digitization has increased considerably with a 2 to 5 times growth in e-commerce as a surge in digital platforms is underway. Again, digitization is both an opportunity and a challenge. As businesses go online, traditional staff such as salespeople and front office workers might be reduced. As technology is being incorporated rapidly into work, employees need to improve their technological skills and be adaptable and malleable to technological innovation and creativity, which increases at a fast pace. Expanding digital infrastructure is important as employees need reliable internet connection to be able to work without disruptions. In Mauritius, for example, there are still some geographical areas which still lack strong internet connectivity. In this respect, government should ensure that access to internet connection across the island is democratized. Employees should be granted additional allowances or an increase in salary to cater for installation of Wi-Fi in their homes, buying of 4 or 5G packages, upgrade to software and hardware used at home, etc. This should also be reflected in relevant legislation. Finally, what are some of the recommendations that are proposed at this stage of the survey, of the research? Companies have a new opportunity to reimagine how and where work is done, thinking about specific work arenas and occupational activities. Speedy and effective worker redeployment will be needed even beyond the pandemic, for example, by recruiting and retraining based on skills and experience rather than academic degrees. Policymakers might consider prioritizing equitable access to digital infrastructure, as well as new ways of enabling occupational mobility. As the share of independent workers grows, more innovation, especially technology-wise, may be required to secure benefits for them. The pandemic is already fading, but the agility and creativity of policymakers and businesses evident during the crisis will need to continue, no doubt, to find effective responses to the looming workforce challenges ahead. Business leaders and policymakers can build out digital infrastructure, enable faster reskilling, and innovate new worker benefits and support mechanisms. Employers should enable labor market flexibility by removing barriers to worker mobility and equipping workers facing job transitions. Preliminary results from the survey highlight that employees understand the importance of physical proximity as a factor shaping the future of work. For this reason, even if employees do favor the adoption of remote work, there should be means to include some aspects of proximity through, for example, online breakfast, lunch, coffee meetings, setting up of fun online sessions such as quizzes, games, etc., where staff can unwind and bond during breaks. Technology-wise, employers should invest more in deploying new digital solutions for staff, such as video conferencing, document sharing tools, as well as expansion of cloud-based computing capacity. Employers should also organize regular training sessions so that employees are kept up to date with advancement in technology to make remote work more effective and dynamic. As work shifts to remote or hybrid mode, employers should also allow for more flexibility in terms of how employees organize their work schedule as they cope with household and family obligations. For example, staff should set up meetings, work sessions, and the like after proper consultation with their team members to avoid clashes in terms of schedule. For this purpose, planning ahead is key and should be stressed upon. Employers should also provide more mental health facilities and services to staff as employees continue to cope with the upheavals caused by the COVID-19 pandemic, adapting to new and daunting modes of work. Thank you very much. This was my presentation, and I welcome any questions from you. Thank you.
Thank you very much, Krishni, for this very interesting presentation and sharing some of your preliminary findings with us. So I think we'll proceed with asking the people here if there are any questions for Krishni. Yes, so we have a question from Morena.
Thank you. Good afternoon. Thank you for the presentation. So what is your professional view with regards to employees equally being trained to know how to work from home? And this we obviously observed during lockdown that, and I was venting out earlier to one of the colleagues that some of the frustrations that we experienced, I'll share just a few quickly, were in an event where a meeting starts at 9, the employee would only log on or switch on their laptop at 9. And then for the next 20 minutes, we are idling there waiting for the person to get online. We are equally observing now what we call the presentism, where, the person is online, but when you call out for them to come do their part, they are just nowhere to be found, but they are online. Some of them have equally been found walking around at the mall, but they are actually online. So certain times become off limit for work. So you now can't schedule meetings at 2 because I'm going to pick up my baby. So these were serious challenges. And of course, if we want to avoid resistance from the employer to, of course, to embrace this work from home, what are your views, but also what guidelines also could we use to assist us in training employees? Thank you.
Yes, I will answer this, and then maybe Pratima can, who is also part of the research, can answer. I think professionally and personally as well, the things that you've mentioned, we have experienced it in Mauritius and also at the place where I work. So unfortunately, I think what we can rely on is, first of all, the own sense of professionalism of the employee, the staff, okay? And the second, and this ties in with ethical considerations as well, and also making sure that if the employer is offering you this kind of flexibility to work from home, or to have at least like hybrid work, 3 days working at the office and 2 days working from home, I think the onus is on the employee to make sure that they are grateful for this kind of flexibility and that they find a way to make it work. I mean, from my own personal experience, I am aware that a lot of emphasis has now been put on, work-life balance, on, realizing that when women as the workforce have had to cope with household duties and looking after the kids, making sure that they are being homeschooled properly, that the burden has fallen on women, and also having all these kinds of burnout, stress related to working from home during the pandemic. I think a lot of emphasis has been put on making sure that there is this work-life balance. But at the same time, when we talk about work-life balance, we should think about work. It's not just life. So I think that there's a sense that there should be, the legislation should be amended to cater for these changes, and the legislation should be very clear. And at the same time, apart from legislation, there should be policies and guidelines from the companies themselves, and this should be done in a concerted approach. Maybe there could be the government, the private sector, the public sector, trade unions, representatives of workers, unions coming together and agreeing on these guidelines to make sure that this works and that at the same time it works not just for the employees, but it works for the company itself. Because at the same time, we still need to respect that, we still need to keep production levels, productivity levels. We still need to compensate for all the losses that have been made during the COVID-19 pandemic. So I think the easy answer is that employees and staff should themselves recognize that they need to be professionals in their work, and they also need to have ethical standards, because if we are going to be flexible, then we need to respect each other's boundaries. We need to respect that there needs to be set times where everyone is available for meetings, for work sessions, and then I think that would make it work. So maybe Pratima can add something on that.
I think you've said a lot of things I would have covered, but I think the onus of making it work is both on the employee and the employer. And it's also about the organization. I don't think laws can change these, because these are proper to the organization. And for example, if your head of line manager may be a very concerned person and may decide that no meetings will take place at 9 o'clock because all my female staff are dropping their kids off at school, that's something which is at departmental level. Or at organizational level, they may decide there won't be meetings on a Friday. Fridays are meeting free. So if you do want to go to the mall on a Friday, you could choose Friday. But there's no right and wrong answer. I think it's something that needs to work for both parties, and everybody is learning through the process. Thank you. Do we have another question for Krishni? Yes, we have one more question.
Necessarily a question, but a comment to say, the issue of commitment to work. We spoke earlier about the benefit of value to the employer vis-a-vis the services that the employee offers. That it's not more about the changing of laws per se, but it draws more on competence of the employees, because much as you can train, I agree, but the willingness and the competence of the employees to do the work, it really comes with a lot of value to the employer, because working from home is not a holiday to the employees that you have, that gives you time to do errands and run and do visits and family. And yes, you might do that, but it has to come with discipline. We also discussed the issue of senior managers who are not obliged to report daily to the office. But in between that, they have to make sure that they attend to virtual meetings, make sure that there is service delivery in line with the I don't want to say the benefit, but the advantage of not being in the office on a daily basis. Yeah, I think it come along with more of competence.
Yeah. I agree. I think, and also the nature of the work, some nature and, position of the work as such, like you said, senior managers do not necessarily need to be there, but they're still able to, be more flexible around when they, I think it's possibly because they are having more control over their time compared to those below them who have to report more often. So that potentially these needs to be looked at, not more at a overall thing, but looking at different types of employees who have different requirements as well, and competences, as you say, because they won't react to the changes in the same way. Yeah, well, thank you. That was a very good comment. I think we are done with the session, Krishni. Thank you so much for coming over online today, and we'll hopefully see you face to face tomorrow.
So Dr. Edwin Coleman completed his BA in Political Science and Information Studies in 2012 in the University of Ghana. And in 2016, he did his LLB at the University of Cape Town, Cape Coast, sorry for that. And then he also obtained his LLM in International Commercial Law from the University of Joburg in 2018. He also received the coveted Global Excellence Teacher Scholarship from the University of Joburg to pursue his doctorate, LLD. He completed his Doctor of Laws in 2020. He's an alumnus of the Hague Academy of International Law in the Netherlands, and has also completed an internship program at the Permanent Bureau of Hague Conference on Private International Law, also in the Netherlands. He has served as researcher, as a research fellow on the Institute of European Law in Saarland, Germany, and is currently engaged as a postdoctoral research fellow at the University of Joburg under Global Excellence and Such 4.0 scholarship. He publishes on labor law, social security, contract law, international commercial law, private international law, and human rights. And he's also a member of ALLS, International Human Rights Group, and also SASLO. He's going to talk today about collective bargaining and representation in the gig economy in the Southern African Development Community. And he's also going to present on behalf of Professor Mpedi, who is a Vice Chancellor of University of Joburg, South Africa, who's been working on different issues from environmental law, climate change law, diplomacy, international commercial arbitration, communication skills for lawyers, IT and the law, climate, but also gender and mental health. He's a global shaper and lawyer. He's also a PhD student at the University of Western Australia, where he's enrolled through distance learning at the law school. So, karibu sana, welcome. Doctor.
Thank you so much. I think a quick one, Professor Mpedi's profile was a little bit mixed up a bit, but then maybe I will update the profile shortly. But as you rightly said, I'm presenting on behalf of Professor Mpedi, who is the Vice Chancellor and Principal of the University of Johannesburg. So it's a co-authored contribution that we are working on collective bargaining and representation in the Southern African Development Community. Just by way of overview, this presentation would deal with three main things and basically provide an overview on the employment status and debates in the gig economy. Also reflect on the modes or modalities of accommodating gig work in the Southern African Development Community under the collective labor laws in the SADC, and also call for a need for a purposive approach in terms of construction and interpretation of labor laws to accommodate emerging forms of work in the SADC community. To commence with the debate, I know that this is a discussion that is still topical and most of you might have familiarized yourself, so I will not spend so much time on the first part. But the Southern African Development Community, there are some countries that have witnessed monumental growth, economic growth over the past years. And it's unprecedented, and due to the economic growth, such as in Malawi, Tanzania, South Africa, Botswana, and Namibia, due to the unprecedented growth, there's this governmental push towards this digitalization agenda. And this has led to a growing digital economy that also has an impact with the proliferation of new modes of employment. And in South Africa, the government instituted a presidential commission on the fourth industrial revolution to look at the multi-sectorial viability of the fourth industrial revolution, which the digital economy is part of, to look at that multi-sectorial viability, particularly the economic viability of the fourth industrial revolution in a South African context. And as I said, the digitalization agenda has also led to the proliferation of new modes of employment, particularly platform work, and common, as you might know, is Uber Eats, and the rest. And contrary to some misconception that most of these platforms are foreign owned, There are some appreciable locally or African-owned platforms, labor-related platforms that are analogous to that of Uber and the rest. So there's this, it's a climate of competition in one way or the other where labor standards must be upheld. And the graph on your screen shows the extent of contribution in terms of private digital platforms and also the distribution foreign-owned and African-owned platforms. One of the things that must be mindful or I need to mention is the very nature of the gig employment, which is characterized by short-term jobs, temporary work, and also flexible forms of employment, mainly conducted by those who provide sort of autonomous services, such as independent contractors and the self-employed. And in Africa, particularly the SADC country, which has been rocked with some form of rising unemployment, particularly youth unemployment, the gig economy is a propeller in alleviating some of the harsh socioeconomic conditions that many people face in the region. But then the unfortunate thing is that within the SADC system, the regulatory framework, as well as the very working relationship of those that participate in the gig work, so the giggers, and also the platform, the digital platform providers, is unclear. It's not clearly established, and due to that, there are some labor practices, unfair labor practices that go undetected. And also this is as a result of the improper characterization of their working relationship. Other legal challenges arise, and these challenges are multifaceted, stemming from monitoring and compliance, also issues of fair remuneration and determination of wage, the challenges and modalities of engagement. In many instances, these digital platforms employ adhesion contracts, standard contracts, where most of the drivers or most of the participants or giggers do not really understand. And also most of their policies are inaccessible and also very difficult to comprehend. But the most important issue is that in all of this, the contours of collective representation and bargaining haven't been clearly explored, and that is what we are going to deal with today. We are going to deal with representation, voice, collective bargaining, and other collective labor rights that are important for purposes of smooth functioning of the labor market. So some of the issues such as due process for gig workers is very important. The development of proper channels where grievances of gig workers can be heard, and also the freedom of gig workers to freely organize themselves for purposes of demanding better working conditions, the right to strike. These are important collective labor laws that must go hand in hand in ensuring that gig workers are protected under statutory law. To put it into context, and how Prof. Mpedi and I commenced this research, sometimes during COVID, e-hailing drivers, particularly Uber and Bolt, in some SADC countries decided to embark on strike. And one of the issues they raised was the fuel hikes and also the rise in the cost of necessities. So which then means that it impacted their profit. And also they complained about issues of the commission that Uber and Bolt takes at the end of the work that they've done. As at the last time I checked, it was 25%. And even in Tanzania, it became a very topical issue where the government wanted to set a commission cap on the commission that Uber takes from the income generated from the works of the drivers, which led to them winding up and leaving operations in Tanzania. Now they've resumed, which we'll discuss with it on how to balance these competing interests. Now, with them embarking on strike and demanding better working conditions from the platform providers, some of the issues that came to mind is whether they have a legal basis to demand better working conditions through such collective actions such as strike. And in any case, can the existing legislative or statutory framework afford them or accommodate them in terms of affording them that degree of utilizing the levers of, for instance, collective bargaining, representation, right to organize, and right to strike as a springboard or a conveyor belt to demand better working conditions from the digital platform providers. And obviously with COVID, things became very dire. And in some cases, the strikes continue. In South Africa, we witnessed about 3 or 4 strikes. Even this year, they've cautioned about another strike to embark on. And with COVID, one of the reasons is that, in fact, the macroeconomic challenges presented by COVID makes it very difficult for these drivers to cope. And another important issue that is on our heart and which links to gig work and which we describe as the duality or double-layered precarity and vulnerability is the situation of migrant workers within the Southern African enclave with this avalanche of movement of people from other Southern African countries to other countries. It becomes very important to assess the extent to which we can mitigate the vulnerability of migrant workers, particularly those that participate in the gig work. Other legal issues include occupational health and safety in South Africa. Issues about violent crimes, hijacking, and the rest have come up. And these are issues that can cumulatively and collectively be dealt with using collective labor laws such as collective bargaining, the right to organize, and the right to strike to remedy it. But the problem lies with the very employment status of gig workers. The mere fact that it is not clear as to their working relationship makes them fall outside the statutory barriers, in which case it becomes very difficult even from a governmental standpoint to extend protection to the gig workers. And I will not go through the debate in terms of their employment status. What I can say is that there's this wave in many jurisdictions regarding pronouncing gig workers as employees. In the case of the UK Supreme Court relied on the intermediary category, which is the worker, used to remedy the labor market dysfunctionality, where certain categories of people that do not fall under the employee definition from getting statutory protection. So the UK pronounced them as workers. And the wave continues, unfortunately, in South Africa, as academics have highlighted. South Africa missed an opportunity when the issue was presented before the labor courts to pronounce on the employment status of gig workers. Also in Nigeria, I wouldn't say the opportunity was missed. I would say that if the parties had presented sufficient facts, the court would have ruled in their favor. And that is a case that ushers our discussion into something that is very interesting, where this whole idea to look at contractual arrangements purposively and not just to constrict working arrangements within the rubrics of a contract of employment becomes very important in this discussion. With that being said, what are some of the ways through which gig workers can be accommodated under the collective labor laws of South Africa, of Southern African Development Community? Our argument here is very simple. That looking at the complexities associated with pronouncing gig workers as employees and some of the impact that it can have on these companies in terms of the digital platform providers, some seeing operations in SADC as not attractive enough and therefore they will wind up and leave, it is important to strike a balance. So in our case, we are arguing that gig workers need not be pronounced as employees, but they can still enjoy certain statutory benefits looking at the overall legislative framework the statute in most SADC countries and how that can be construed purposively to ascribe statutory protection to gig workers. And I'll provide reasons why such approach becomes very expedient and necessary. Don't forget, already many African countries, SADC countries, are experiencing macroeconomic issues, of which was exacerbated by the COVID-19. So we need to find some realistic measures that balances the interest of digital platform providers who are playing a very enormous role in alleviating poverty, resolving unemployment issues, but at the same time ensuring that the participants thereof are not deprived of the relevant statutory protection. Conventionally, access to collective labor laws, be it the right to organize collective bargaining or representation, the right to form or join a trade union, these are rights both under international and domestic law linked to a person's employment status. So those that provide subordinated labor, that is workers and employees, and not those that provide autonomous service such as independent contractors or the self-employed. And so as a result, even the formation of a trade union for purposes of advancing the interest of their members is sort of linked to the employment status of a person. And if you look at the Labor Relations Act of South Africa, Tanzania, Namibia, and some other SADC countries, these are rights that is linked to a person's employment status. So by nature, by the contractual arrangements of gig workers and the digital platform providers, they are excluded from enjoying these statutory benefits. So if you look at it, the entire labor architecture in most of these SADC countries are predicated on the employee status of a person in terms of whether collective bargaining or other collective labor law related issues. So for instance, the right to strike, which is an essential tool in most SADC countries, is linked as a tool that can be utilized by trade unions. And before one can join or form a trade union, the person must have been an employee. That dialectic sometimes creates a problem. And also in instances where even the right to strike is linked for purposes of collective bargaining, which it is trade unions that engage in collective bargaining to pursue the interests of their members. But if you look at South Africa, which we propose that the position which was touted by the South African Constitutional Court, that is the flexible approach in construing labor relations under the South African Constitution to make it all encompassing and to include employment working relationships that are akin to employment relationship. We believe that is broad enough to capture the working relationship, emerging forms of working relationship, so that gig workers in this context can enjoy the tool of strike to demand better working conditions. Similarly, in terms of the formation of trade union, the South African Constitutional Court in the Sandu versus the Minister of Defense and another case is very important, where that profound principle was enunciated, that to avoid instances where the actualities of the working relationship provides otherwise, but the contract mischaracterization or characterization shows that a person is an independent contractor. To avoid that, it is important to look at the real working conditions between the parties, in which case now one has to look at the fact and the broad circumstances surrounding it to pronounce on whether a person is a worker within the context of the South African Constitution. This is a very broad and purposive approach to look at the very nature of the working relationship as opposed to the contractual relationship, which can often exclude many gig workers. To move on very fast, I will highlight that the purpose of collective bargaining, which will be very useful in the gig economy and also for gig workers, includes to balance out the unequal working relationship, and also to democratize the working relationship through putting in place structures for due processes or to ensure that the grievances of the parties have been heard. So it has a democratization effect, and it's also to ensure that unequal balance of power in the working relationship is evened or leveled out. But the question then becomes whether gig workers, by their nature or by the very current contractual working arrangements, can involve themselves, can collectively bargain. That is a very important question. So it is not necessarily even about a question of gig workers. The conceptual issue that arises is whether independent contractors and also self-employed persons can collectively bargain within the framework of the law. And in some jurisdictions, particularly in Europe, this green light has been given in terms of collective bargaining for purposes for independent contractors and the self-employed, especially when it is through their permitted representatives. So these are important issues. But even if independent contractors can engage in collective bargaining, the question is, does that accrue to them as a matter of right within the South African enclave? To some academics, within the Southern African enclave, to some academics, extending collective bargaining rights and collective labor law right to independent and self-employed persons is counterproductive and unnecessary. And this is because of the very complex nature and also the voluntary nature of collective bargaining, which ensures that by virtue of this voluntary nature, an employer can decide with whom to negotiate it with, and you cannot compel this employer to negotiate unless that association or that registered association can use the levers of strike to sort of nudge an employer to negotiate. So if we are able to properly situate the significance of collective bargaining within the gig economy, then it means that gig workers can use these collective labor laws and the rights associated with it to advance their interests and to also negotiate for better working conditions for themselves without necessarily being pronounced as employees or otherwise by court. So these are some of the rights that can, these are some of the host of rights that can be very important in the gig economy. And we are saying that it is important for gig workers to enjoy collective labor rights. So we are proposing two routes. Either there's a liberal approach to construing collective labor rights, in which case that approach should be purposive, looking at the actualities and the realities of the working relationship, or you pronounce them as workers, and that has been the emerging literature, and the literature, the preponderance of the literature focuses on pronouncing gig workers as employees and based on which they can be entitled to statutory rights. We are saying that they need not be pronounced as employees, but through collective labor laws and the enjoyment of collective labor rights, one, they can be able to advance their collective interests and also push for better working conditions, at the same time also fall within the umbrella of the law, because negotiations and collective bargaining is regulated within the framework of the law. So I don't know whether you can still hear me.
Yes, we can.
Yes.
Thank you. Thank you so much. Thank you so much. So what is this purposive approach that we are talking about in the context of construing purposive labor laws within the Southern African Development Community in that liberal and broad manner to capture the realities of the working relationship and what is the essence thereof? So the South African approach, which we believe can be a springboard or can serve as legislative and judicial lessons for other Southern African development, the members in the SADC, is that the working relationships should not be construed strictly from the lenses of contract law. So now we are moving beyond contractual relations between the parties where one has been designated as an independent contractor, and that is it. Like the Nigerian case of Tunji, where the judge indicated that even the terms of a contract can be disregarded, especially when the reality surrounding the working relationship is at variance with what has been stated in the contract. So if you look at the working relationship between gig workers and the digital platform providers, where even issues of control, integration, the extent of standard setting by the platform providers, these are some of the factors and indicators that can be used to say that no, in as much as they might not be employees from a contractual dimension, their working relationship is akin to that of an employment relationship, based on which they can be entitled to enjoy collective labor rights and the labor laws within the domestic setting. So such construction, purposive construction, can operate to extend statutory protection to atypical workers and also self-employed and independent contractors such as gig workers. So we've used this to circumvent the rigidities and complexities that might be associated with pronouncing a gig worker as an employee, in which case they would have to pay tax and also subject themselves through other forms of rigid employment process and domestic process. We've used this to circumvent that explicit pronouncement, but at the same time, these gig workers can get the required statutory protection under the labor laws. And also, I mentioned earlier that it's important to approach this from a balanced perspective, where in the case of Tanzania, Uber felt that no, the governmental interference in terms of the commission cap was too much for them and made their operations very not profitable in Tanzania. Now they've resumed, but the point then is that it is just a point of call in many instances to balance these competing interests, whilst these platforms exist to resolve or solve a specific socioeconomic challenge, such as poverty and unemployment. It is important that we maintain them so that over-regulation and the rigidities that comes from statutory regulation will not deter these platforms from moving to other countries, because their essence cannot be underestimated. On the other hand, too, we cannot let these platforms have a field day. We should be able to hold them in terms of the fair labor practices or unfair labor practice that goes on the platform, the remuneration, the entitlement of workers. We believe that these are entitlements that can be incorporated into the negotiation agreement or agenda during the collective bargaining process, which eventually becomes part of the individual employment contract of those that bargaining applies to. So that is a way of circumventing the rigidities of employment, the current statutory framework, but at the same time ascribing statutory protection to gig workers. It will also afford the gig workers themselves that opportunity to lawfully and legally, through the ambit of the law, to negotiate for working relationship that is beneficial and that is context specific to them and that protects their collective needs and interests. So the point we are making is that the enjoyment of collective labor rights, which hitherto is, and in many instances in the SADC region, is linked to employment relationship, is linked to the employment status of a person. We should move beyond that and construe working relationship from a more purposive, broad and liberal manner to include working relationship that mirror employment relationship. And through that, gig workers and emerging forms of work can be captured under such an umbrella. So this, we believe, will ensure optimal protection for gig workers in the Southern African enclave. So, and the point is, one of the counter narrative and argument that is advanced by some some academics is that, and I mentioned it, that some academics believe that extending collective bargaining rights to self-employed and independent contractors will be counter-narrative and also unnecessary, especially when one has due regard to competition law. But if you look at the construction and the purposive assessment that we've done and the circumvention of the normal academic assessment that they should be pronounced as employees to now enjoy these type of rights. If you look at that circumvention, it becomes very important now. No, we can extend protection to you, but this protection in reality is not disrupting the existing collective bargaining framework that we have in the SADC countries. It is only realigning the existing collective bargaining framework, statutory framework, to accommodate emerging forms of work and new forms of work, which it is important for the law to consider. When the law does that, and when the law looks at it from this all-encompassing perspective, it will, on the one hand, ensure that the gig workers and the independent contractors, as they've been characterized in their contract, will get that statutory protection on the one hand, through their negotiations, collective negotiation with the platform providers, and also the platform providers existing to resolve some socio-economic issues in the SADC enclave. And as Bog mentions, he stipulated that the extension of the boundary of collective labor law to employee-like persons realigns collective labor law to ensure that new forms of employment, self-employment, are brought within the scope of collective bargaining protection. And that is what I just mentioned. It is just a realignment of the existing collective labor laws to ensure that emerging forms of work, such as the issues that we are dealing with in terms of the mischaracterization or characterization of gig workers, is properly dealt with within the framework of the law, because negotiation, collective bargaining, representation does not operate outside the ambit of the law. So once we are able to capture such workers through construction of such working arrangement from a purposive and broad manner, we are basically realigning the existing collective labor laws to suit or to accommodate these forms of work. In terms of conclusion and some remarks, we would say that gig work constitutes an important part of the labor force in the SADC market, SADC labor market, and decisive measures ought to be taken in terms of dealing with whether the characterization of or the mischaracterization of the working relationship between gig workers and the digital platform providers. And it's very important, especially having regards to the migration, the movement of people occurring in the SADC enclave, so that that duality or double layered precarity and vulnerability in such instances can be averted. So an institutional framework is very important in addressing some of these issues in terms of the needs of gig work. So to ensure that labor market equilibrium, it is important to take those decisive steps to level the ground in terms of protecting the interests of gig workers and also ensuring that the digital platform providers, who are mainly driven by profit, do not also feel the pinch and leave the SADC enclave. That is from the side of institutional framework. Also, there is the workers' organization framework, let me put it that way, from the side of trade unions, that the trade unions can challenge existing framework that mischaracterizes gig workers. And these are some of the ideas that the trade unions can push. And the moment they do that, it will be one of the ways of organizing and opening the room for new members to join trade unions. And in South Africa recently, I heard about 5,000 Uber and online drivers have joined the leading association or trade union on transport, which is good. And also, which means that trade unions must be very proactive. They must challenge existing laws that mischaracterizes the working relationship. They must ensure that as these new modes of employment are changing the face, the organizational structures of even trade unions, they devise innovative measures to ensure that new members join them, whilst the issues that preclude members from even being in the labor force in the first place or being taken advantage of in the second place are addressed within the SADC enclave. On that note, thank you so much for joining us for this presentation, and we are grateful.
Thank you very much for that presentation. I'm going to quickly open it up for any kind of question or remarks from the people present. Do we have any person who is joining us virtually apart from the presenter? Yes, there are 10 people. So we are opening it up for remarks or any kind of questions, either from colleagues joining us virtually or anyone who is joining us here physically. But maybe okay, you can continue.
All right, no, thanks, Theophilus, for your presentation. Mine is just a reflection. I've been in one of the other presentations, and there was a paper also around the Uber. And what was coming out is more or less like what you're presenting, but on the basis that the Uber drivers are not protected, and legally they went through the codes trying to address their issue with the Uber, but then the issue was that they were not being recognized as workers. Now, you presented also around the same, but bringing out the issue of the relationship that needs to be built according to the way forward. But my question is, let's say the Uber drivers, they get the right to strike. What would be the response of Uber in terms of that? Will they just sit around and say, it's fine, let them strike? Or will they be able to go into negotiations with them, recognizing them as workers? Thanks.
Thank you very much. We have two more comments or questions, yes?
Thank you for the opportunity. So mine is a clarity seeking. Extending collective labor rights to self-employed persons. In which context exactly? So for example, so if they needed to negotiate, who do they negotiate with? And perhaps I'm practically defining self-employed persons in my back home South African context. So another example is that, so currently within our trade union, we are having a discussion to start organizing sex workers. And it is a huge, uncomfortable topic because the question is, but who's their employer? They, and yes, they are self-employed. So how do we organize them? And yes, we are ready and we are tempted to accept the challenge as trade unions, but how do we go about it? So if you could just clarify me there. Thank you.
Thank you. There's another question from, I hope you're taking note of the questions that are coming in. Dr. Coleman, yeah?
Thanks, Chair. Mine is a follow-up to this question. Obviously, there are requirements before collective bargaining can be recognized. Particularly here in South Africa, one aspect is that of representativity And so it's such a critical thing in terms of understanding the role players, within this kind of sector. Whether perhaps you have been able actually to explore that. Are we looking for solutions that perhaps are quick for, in order to deal with the challenge that is facing us, where we could simply have to ensure that we extend rights to vulnerable employees instead of having to deal with definitions and all these kind of things and so on? But why don't we just look at what are the appropriate rights that we can extend to vulnerable and those people that need those kind of protection, and which one of them, are these? The other one, I'm listening with a lot of interest. I was looking forward to this presentation, and perhaps Prof is not here. I wanted to engage both of you. You continuously referring to gig workers. The term gig, to me, I think it's a bit misplaced in terms of what I'm hearing from you, particularly the examples that you are throwing in here, which to me seems to be on demand, kind of platform workers rather than gig workers. You get that point? Because if you talk about gig workers, you'll talk about the general kind of people in arts, entertainment, and all those. That's gig. That's where the term gig comes in. And we need to be careful in terms of what is it that we want to deal with? And then in terms, because it will be lost in translation by broadening the kind of thing, and we are not going to be able to deal with the kind of challenge that is facing us. So please, I think it's my advice that you need to be careful in terms of the words that we're using when we have to address something and so on, the terminology that is applied in this case. Please, if you can, look, crowd workers, you didn't mention them, but you still refer, to gig, So I'm quite interested, and I'm sitting here, what are these people talking about? What are the issues, the kind of terminology? Thank you so much. Yeah.
Thank you. So I hope that you're still continuing to highlight, because it seems that everyone in the room wants to make a comment or a question. Yeah, go ahead.
Okay, thanks, Prof, for your informative presentation. I think I'm also sharing the questions and concerns by other participants. First, the term gig worker, I think has not reached full maturity. I'm looking at a platform worker. I live with one at home who on some project, one part of the project is cooperating with somebody or collaborating with somebody in India, or on a second section is collaborating with somebody in the UK. The next part of the project is collaborating with somebody in South Africa. But at the beginning of the journey, they have collectively negotiated a fee for all those components. They have looked at what they need in terms of what they need as a payment. Then on the other hand, they want to, I'm just looking at the guy now comes back and says, I'm an employee for just a component of the work that he did for me. And for the time that he spent on me, he works for 3 different people in 3 different countries. I'm looking at a chartered accountants, for example. I know chartered accountants living in Zimbabwe, but working in South Africa, Mozambique, and Malawi. And they deliver work every month, and then they get their paychecks. It would be very difficult to make those people employees, because the thinking is, if you have decided to be a gig worker, negotiate everything in your invoice. Why would you turn around and also say, but I'm an employee? Yes, by definition, they could actually be dependent on you and many others, but they are not entirely dependent on you. When you have no work, they go elsewhere. And in most African countries, if you look at collective bargaining, is either sectorial or industry-based. Yes. Which industry or sector will they negotiate with? Those are the questions that I'm looking at.
Okay, Dr. Coleman, you have less than 5 minutes to respond. Actually, 4, less than 4 minutes to respond. Thank you. We can't hear you. I think you're still muted. Not yet.
Can you hear me now?
Yes.
I'm saying that is a lot of questions to respond in 4 minutes, but I'll try.
Please try. Please try. Please try.
On the issue of gig workers, so first of all, let me say that the terminology gig economy is an all-encompassing terminology that we are using to take care of those facets, especially those ones where people are largely dependent on, and not necessarily the fleeting ones, those that come for 30 minutes. But the point is that it is an all-encompassing term, which, as one of the one person in the audience mentioned, that it hasn't still reached that stage of maturity. It is still an evolving concept. But that notwithstanding, the point is that there are strands of labor issues in there. And those strands of labor issues must be dealt with. For instance, you raised an issue of a person working in different countries. In fact, that is actually a paper that a colleague, Prof. Mpedi and another colleague and myself are working on in terms of the conflict dimension that these issues present. So someone is working in Zimbabwe, someone is working in, let's say, Tanzania, another person in South Africa. That presents a conflict of law issues, which is one of my areas, in which case, what should be the applicable domestic law to such contractual arrangements? That is something that must first be determined. And some of our suggestions in that paper is that we should look at the lex loci solutionis, that the law of the place where the performance took place. So if the person is an Uber driver and the contract, they've written the law of Spain, reality should tell you that no, the performance of the contract, the connecting factors of the contract point to, for instance, South Africa, in which case the law of South Africa should be the applicable law. That takes us to another domain of or area of law that this gig work becomes very applicable. So I understand it is an evolving concept. It hasn't reached the stage of maturity yet, but there are some strands of legal issues that are coming up that requires specific arrangement to be dealt with. The other point is worker. I think some of the issues that I've mentioned here is not to necessarily pronounce them as workers. I don't know whether anyone can recollect where I'm saying that the preponderance of academic study is saying that, you know, if you look at the domestic context and all those things and the working relationship, gig workers, using the term in an all-encompassing manner, should be pronounced as employees. We are saying that can even bring some rigidities and complexities, especially issues of tax, so many issues that can follow, and even not making the economic environment convenient for the digital platform providers. But what can we do? The thing is, we can look at the existing labor laws purposively to not pronounce them as employees or workers per se, but we are saying that the working relationship should be akin to that of an employment relationship as was determined by the South African Constitutional Court. So that is an idea that we are pushing across, in which case they may not necessarily be employees, but in terms of enjoyment of collective labor rights, looking at the very arrangements that they might find themselves. So one, they can enjoy it by extension.
You have 1 minute.
The other issue is practicality, self-employment in the context of what? In the context that there are some working arrangements where one sees it as one of self-employment, but if you look at the working arrangement in and of itself, it is one that moves beyond self-employment. So in which case, because of the mere categorization of someone being, for instance, an independent contractor, it means that person is excluded from employment protection. The point we are making is that no, look at the actualities of the working relationship. For instance, in the context, I don't know much about the sex industry. What I'm trying to get my head around a little bit in my research is the commercialization of sex within the domain of legal paternalism. It's more or less on jurisprudence. But I don't know how the sex industry and the trade union itself works. But what we have seen in the context of gig workers, Uber drivers, and the rest is that they are moving in unison to resolve a particular problem with their employer. But this problem is not captured by the law. So how can we capture these problems with the law by ensuring that they are afforded the protection and also negotiating for better working conditions as the case may be? So that can be one of the contexts to look at it. I hope I have exhausted my 5 minutes.
Thank you very much. That was quite insightful. I know that there are some questions that you are not in a position to answer, but I hope that, unfortunately, you're not here. I hope that when you're going for cocktail, actually it's already time, that we can actually engage on some of the questions. Thank you very much, everyone who's joining us online, for joining us, and have a lovely evening. Bye.
Thank you very much. Bye.